Before we begin, however, I would like to acknowledge that we are broadcasting on traditional lands. For me, I'm broadcasting from the land of the Widjabul-Waiable people of the Bundjalung Nation. We pay our respects to the elders of the land, both past and present, and we also extend that respect to other Aboriginal and Torres Strait Islander people attending the webinar or watching the recording. Welcome to this Legal Aid New South Wales webinar on coronial processes and inquests. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. This session will be an hour in total, and that includes time for questions and answers. After the webinar, you will receive an evaluation survey, and we really appreciate your feedback and take that into account when we do our planning for the year. You'll also receive an email following the webinar with information about any resources that we talk about in the webinar today. I'll introduce you to your presenters. Danielle from Legal Aid's Coronial Inquest Unit. Welcome, Danielle. And Fionola from the Coronial Information and Support Program. Welcome, Fionola. Just to let you know, we're going to run the webinar as a question and answer format. And so, Danielle, I'll start with you. As I've told our audience, you work in the Coronial Inquest Unit. What type of coroner's matters might the Coronial Inquest Unit take on, and therefore who might be able to get help from your unit?
Thanks, Bridget. Just before I answer that, I also just want to acknowledge country. I'm on Gadigal, land of the Eora Nation, and I, as a Wiradjuri Gomeroi woman, pay my respects to this country and acknowledge that it always was, always will be Aboriginal land. So, look, the Coronial Inquest Unit is a statewide specialist service of Legal Aid New South Wales, and we provide free legal advice, assistance, and representation in coronial inquest matters. And we provide advice and limited minor assistance and to anyone who may be involved or want a deeper understanding of the inquest system. We also provide advice to persons of interest and witnesses, and we appear at inquests across New South Wales. So that's in both metropolitan and regional areas, and in regards to the deaths of persons or missing people. And we also provide some strategic law reform in regards to systemic changes that we want to see in the system. So we can provide advice about the coroner's court and coronial inquests, as I said, to anyone. However, usually minor assistance or a grant of legal aid. So the grant of legal aid is when we provide a lengthier service to someone, is usually provided to a deceased person, senior next of kin, or their family. However, in some circumstances that we may also grant aid to someone other than the senior next of kin, provided that they have sufficient interests in the proceedings. And in terms of when we grant aid and represent people in coronial inquest matters, usually there has to be, they have to obviously be related to an inquest in New South Wales, but we also have a public interest test, and we need to be satisfied that there is a public interest for us to grant aid. However, we also do appear in matters that involve the death of a First Nations person in custody, and that's automatic. So if you don't mind, I'll just explain a little bit more about the public interest matters and what that actually means so that viewers understand. So we're available for public interest matters where our representation would advance the public interest. And so that's a collective interest as opposed to an individual interest. So a public interest is something of serious concern to the public at large, or a significant section of the public, such as a disadvantaged cohort or marginalized group. And for something to be of the public interest, like I said before, it must amount to more than just a private right or an individual interest. Although, we acknowledge that the two may coincide at times. So to provide some examples of matters or inquests that are likely to have public interest attached to them, you might see a death in custody matter. So that can involve a death in police custody, immigration detention, or when someone's actually detained by police. There's the death of a child that's in the department's care. There's deaths in psychiatric hospitals, or deaths that involve a matter of public safety that we determine is in the public interest. And then, as I said before, consistent with the recommendations from the Royal Commission into Aboriginal deaths in custody, legal aid is automatically available when there's a death of a First Nations person in custody. So that's our representation in regards to matters within the court. I might also just give a brief overview of how we can help in regards to providing advice and minor assistance. So when we're providing advice to people, we provide free independent advice from the Coroner's Court about coronial matters or the coronial inquest process. So this, as I said before, may include advice to a person of interest. So this is a person or a witness. So this is a person who may be facing criminal charges as a result of the death, or someone who may feel like the evidence they're going to give may put them in a position where they could be liable or face criminal charges. So we can provide those people with advice about what protections they can seek during the coronial inquest process so that they don't face those ramifications. That can also be really important for our families because at times our families come and they want to know the truth and they want to know what happened. And this is an avenue for the person who has that information to get protection, but also the family to get the truth and to understand what's happened. So usually we only provide advice in those matters, and usually full representation to those people at an inquest is not available. In addition to that, there's certain matters that will come to us where a coroner has already made a determination about a matter, and they perhaps aren't looking to take the matter or the death or the missing person to a full inquest, and that can be quite stressful for families. So we can also provide limited assistance in assisting letters to be written to the coroner's court, to understand the decision to not hold or dispense with an inquest. And we can also provide assistance in trying to agitate for an inquest to be held. And sometimes, but not always, when we agitate for inquest to be held, there are circumstances where we then see that an inquest is held, but that's not always the case. But we can always assist family in trying to get answers in other ways, getting documents from the court, sitting down with them and explaining it to them, or allowing, getting meetings with certain stakeholders so that they can get, more of an understanding about why a death may have occurred. So that kind of extends briefly to the minor assistance and the advice that we provide, and then obviously the representation that I've talked to before. Just to expand on that a little bit, usually legal aid does try to keep grants of aid in-house. So our team, we're only a very small team. We've got 3 solicitors and a paralegal. So usually we will try and keep the inquest matters within our team internally. In some circumstances, it will go to other legal aid solicitors outside of the coronial inquest unit. However, private solicitors can also apply for a grant of aid to represent people. As I said before, we do like to try and keep them in-house just because we do have the expertise that's needed for this jurisdiction, but there are circumstances where aid is then granted for private solicitors to then go and represent people.
Thank you, Danielle. So you've spoken a bit about representation in relation to inquests. So for the audience, would you mind just speaking a little bit about what an inquest is and what the purpose of an inquest is?
Mm-hmm. Absolutely. So an inquest is a court hearing where there's a coroner who presides over the matter, and they will consider evidence, evidence by the paper, but also oral evidence that's given by witnesses and persons of interest. And that will go to a number of things. It will go to the identity of the deceased or missing persons. It will allow them to make determinations about the date, the place, the manner, and the cause of death of the person. And during this time, the coroner, as I noted, may also call witnesses to give evidence about their knowledge or the circumstances of why the person's died or gone missing. But that really goes to the fact that what a coronial inquest is a truth-telling process, first and foremost. So they're trying to get answers and they're trying to understand why things have happened. And then that allows them to make findings about systemic issues that may exist within institutions, public institutions, government institutions that we have. And the idea is to make those have those findings and make recommendations about how the system can change so that we don't lose another person to the flaws that may exist within the process. And it's also, attached to that, it does have an element of healing. Or it tries to get an element of healing for families as well, so that they can understand a little bit more about what's happened to their loved one and why it's happened. So that's a really high
So,
level explanation.
yeah, so it's an inquiry and it differs to other court processes. It's not an adversarial process like you'd find in
That's
other courts. Is that right?
Yes, that's correct. So the coroner's court is inquisitorial in nature as opposed to adversarial, which is what we see in our criminal courts and, to some extent also our civil courts as well. Um, so the coroner's concerned with fact finding, not determining guilt and delivering punishment. That's not to mean, though, that adverse findings against organizations or certain people can't be handed down. And that doesn't necessarily mean that, inquest matters won't refer people to the DPP. There's been a number of circumstances where inquests have occurred. They've got, in the early days of the inquest or midway through the inquest, and they've stopped the inquest because more evidence has come to light or it's been referred to the DPP, where they then have to go through a process of, seeking further evidence and seeing if charges need to be laid against people. And that goes back to, that whole protection I talked about for witnesses and persons of interest that we can provide as well.
So that's the Director of Public Prosecutions, and that's the representative of the state that prosecutes criminal charges.
That's correct.
Thank you. And so I'll just change slides now, but the next question that I had for you is, what is the coroner's court and how might it differ from other courts? You've kind of
Mm,
delved into that
mm.
already.
Yeah, yes, that's so. I think we've touched on that already, but what I will add to that is it is quite different to other courts that are adversarial. Um, the family is really important, to the proceedings, and depending on where what courtroom you're sitting in, because obviously the Metropolitan, the Coroner's Court is very different to some of the regional courts, but you will try and have the family up at the front so that they're close to their representatives, so that they can be engaged with at all times. So you're always checking in with them, asking them questions, seeing if they have any questions that they want asked. So you will always try and have them close to you. In some circumstances, they might actually sit up close in, the juror's box or something like that, so that you have that easy line of communication. But you will have the coroner that sits at the top, obviously, and then if there's room at the bar table, you will have the family's representatives. Usually they sit next to the counsel assisting. So that's the legal representatives for the coroner. So the coroner has their own legal team in essence that and their purpose is to kind of get and gather all the information that they need and the evidence that the coroner needs to make a determination. And then you'll have all the other parties that sit next to those two. So it could involve representatives for police, representatives for individual, healthcare practitioners, police officers, or any party that has an interest in the matter that has their legal representation there. And it's different in a sense to other courts, because if it gets too much for the family and the family need a break, there's room to ask the coroner, can we just have 5-10 minutes for the family? That's obviously not something that you would see a lot in a criminal case or a civil case. So the coroner's very in tune to the family's needs in the process as well.
And what role does the police play in relation to inquests?
So it depends on what type of matter it is, because it's obviously going to vary in nature. If it's, for example, a missing person or a death in a health facility, as opposed to a death in custody or a death in police operation. But usually the police will be there. You've got the officer in charge who will provide their evidence or their witness statement if they're called, or it can just be on the paper, but usually they are called, and they will give their account of, what findings they've made or what conversations they've had with people. Then if the police are involved at a higher level, you will have the police called to provide evidence. A lot of the time, the brief of evidence that all parties will receive will have a number of statements from police officers who have been involved. And then depending on the discretion of, the counsel assisting, the coroner, or other parties, there will be certain police officers who we called to give evidence or cross-examined in terms of their manner and their dealing with the proceedings.
Thank you. So what are the limitations of a coronial inquest? So you spoke about how the coroner can make findings. Are those findings binding on anybody, or are there limitations that you see to the process, I guess is the question.
Yeah, absolutely. There is limitations to the process, which is really disappointing for a lot of our families, and probably one of the biggest things that they struggle with is the limitations that are attached to it. A lot of families come into the process and they feel like they're going to go through an inquest and they're going to have all the answers and they're going to know, and that people are going to be held account. But in more instances than not, that is not what happens. They may get they may get a greater understanding of the process, and they may get have some of their questions answered, but there's still a gap that will exist, and that gap means that not all of their answers, not all of their questions are answered. The further limitations are that a coroner, we can go through this process and the coroner can make absolutely amazing recommendations, but there's nothing to actually say that those need to be implemented. It's then up to the government, up to those individual organisations to actually implement them and acknowledge that there's an issue within their organisation. What you actually see happen, not in all matters, but in some matters, is that families will go through the inquest process, but they will also go through their own advocacy process on the side, where they're advocating for change, and they put pressure through media and through their own advocacy to have the system changed. And there's been a lot of successful examples of that happening. We've seen recently in Victoria, there's been pressure put on from a family in regards to Auntie Tanya Day. So that was a death where she was arrested for being drunk in a public place. The family advocated outside of the inquest process for changes to that law in Victoria, and that has only just recently been overturned. So it's no longer against the law to be drunk in public. And so that is going to have a massive consequence, for making sure that people are safe and not dying in situations where they've been arrested for public drunkenness.
Okay, great. Thanks, Danielle. Fionnuala, I might turn to you now. You work in the Coronial Inquest support program. Would you mind telling our audience a little bit about that program and the work that you and your colleagues do?
Yeah, of course. So yes, my name is Fionnuala, or Finn, and I'm the coordinator of the Coronial Information Support Program at the State Coroner's Office. So we're colloquially referred to as CISP much of the time. The program consists of a team of currently 4 professional officers with counselling, psychology and social work backgrounds, who are available to support coroners throughout the state in the management of the coronial jurisdiction. So CISP was established in recognition of the sensitive and unique role of the coroner and the specialised skills needed when dealing or supporting clients who are often distressed and grieving when interacting with the coronial jurisdiction. So our aim is to provide advice, support and information to families across the course of the coronial investigation, and families' experiences of coronial investigations can greatly vary and differ based on the circumstances of their loved one's passing. So it does require, we do have quite a diverse caseload. And further to that, our role is to act as a nexus of communication between families and the coroner, which the coroner will take into account when issuing coronial directions and making recommendations at each point of the coronial investigation. So we do work alongside ASIS, so the Aboriginal Coronial Information Support Program. There are 2 ASIS officers at present working based in Lidcombe. And they mimic the operational roles of CISP officers, though provide specific specialised support to First Nations families who engage with the coronial jurisdiction to promote cultural safety within the court and the support offer. So our day-to-day caseload is quite varied. We work within the CCMU, so Coronial Case Management Unit, and that essentially was formed in 2017 with an objective to develop and implement an interagency unit staffed by the Department of Justice, New South Wales Police Force, and the Department of Forensic Medicine. So the CCMU is dedicated to front-end information collection, clarification and evaluation processes for deaths reportable to the New South Wales State Coroner in the metropolitan Sydney catchment area, though there is also a regional CCMU pertaining to the Newcastle catchment. Now, the rationale for the CCMU is to ensure that coronial deaths are subjected to a standardised initial assessment prior to a forensic pathologist offering their clinical recommendation to the coroner, who is then responsible for issuing a direction that dispenses with any further examination or can authorise a post-mortem examination. So we work within an ecosystem per se, and our role is to advocate and provide a voice for families in that process with use of our clinical expertise and discussions with families. So essentially our role, as noted, it can vary based on the circumstances of the case, but we are responsible for speaking with families when a coronial direction is issued for a coroner certificate, which is arguably the most straightforward outcome that could arise from a coronial investigation, in which the coroner does not see an invasive examination or autopsy to be necessary. We would be contacting the family to discuss the rationale for the doctor, the forensic pathologist, and the coroner's assessment of the cause of death on the balance of probabilities. And we would be indicating whether the coroner has nominated to dispense with an inquest, which is the most likely outcome. I guess that in layman's terms, that means closing the investigation. Or we would be indicating if the coroner has nominated to issue a death certificate and indicated that the cause of death on balance of probability has been identified. But there are some cases where the investigation will not be dispensed with, and that particularly pertains to matters in which there may be care and treatment concerns. So the acute cause and manner of death have been identified, but the coroner may see it appropriate to keep the investigation open for the purpose of further examining or further investigating the care and treatment that was provided to the person prior to the death. In addition to having discussions with families about coroner certificates and the coroner's decision as to whether to dispense or not dispense with an inquest, we will be required to speak with families in cases in which they have raised an objection to a particular examination and the coroner has seen this to be necessary to ascertain the cause of death. So we will be speaking to families about processes associated with maintaining their objection, which in some cases can mean that they are required to lodge their objection in the Supreme Court, or we would speak with families about the option to withdraw an objection, and usually that will come through providing a clear rationale as to why the coroner has seen this to be necessary. I guess managing expectations and clarifying what a post-mortem examination does and does not include. I think Danielle drew on it a little bit earlier, but a big part of our role is about managing expectations and really creating transparency for families about the level of respect and care that is always shown in conducting post-mortem examinations. So we'll always ensure that we're creating transparency and managing families' expectations about what particular examinations would or would not involve. Further to that, we may talk to families when further requests for specialist testing are undertaken. So there are some cases in which coroners may request that particular organs are retained for a determined fixed period for the purpose of undertaking specialist testing. We would also be speaking with families where there are disputes about the senior next of kin appointment or who a body would be released to. So we refer to these as burial disputes, and discussing the legal avenues and pathways to families that are available when the disputing parties are unable to reach resolution independently. Further to that, I feel speaking about this, it's amazing that we do all of this work throughout the week. We do play a role in providing inquest support to families. So although overnight about 90% of cases will not proceed to an inquest hearing, for the families where their loved one's case has proceeded to inquest, we see it as important to ensure that a level of support can be provided to these families, particularly given how distressing the inquest process can be, and often there are traumatic circumstances that have surrounded the loss of their loved one. We would provide inquest support to every family whose loved one's case has gone to inquest, and ordinarily we would receive these referrals from the coroner. It could be from the general public, it could be from legal aid, it could be from the family's legal representative, and it really can vary in terms of the level of support that we can provide based on the needs of the family and the circumstances of the case. But it can range from providing education to families about the inquest process, what it is and isn't, really emphasising that it's a fact-finding exercise versus a hearing in which compensation can be sought or blame will be appointed or charges will be laid. So really supporting families to best understand what they can expect over the course of an inquest. It can involve assisting families to view sensitive materials as well that would be referred to or shown over the course of the inquest hearing. So these could be materials produced by the Department of Forensic Medicine, such as post-mortem reports, which can contain information about the forensic pathologist's assessment of the cause of death, or any materials obtained by New South Wales Police over the course of the investigation, which can include CCTV footage, crime scene photographs. It could include 000 recordings. It could include suicide notes or any correspondence obtained over the course of the investigation, police statements as well, and witness statements. So we'll try to empower families by undertaking a supportive viewing of these materials prior to the inquest, so they do feel as though they have prior knowledge about the progression of the investigation, and also that the first time that they may hear particular pieces of information or be exposed to particular forms of evidence, they're able to do that in an environment where they feel safe and they have a level of privacy and professional support. Inquest support can also involve speaking with families about family impact statements that they can present to the court, usually in the last day of the hearing, and really providing guidance, resources and information about what may be appropriate to share, or and really assisting them to kind of process their thoughts and think about what they really want to be made known to the family, to the coroner in the courtroom about the impact of the loss on the family. At times we can provide in-person court support, that no one case is the same, but we certainly as well will screen for any issues or potential barriers that may limit someone's ability to participate in the inquest. So we would be asking families if there are any accommodations that we can make for hearing impairments. We would be setting aside a private room at times so families can excuse themselves and have a level of privacy if it does become quite overwhelming over the course of the inquest hearing. So we really try to provide that clinical support, but also look to see in a preemptive sense what practical support we can provide to families. So on the day of the inquest, they can know what to expect. And we really do have supportive mechanisms in place for them over the course of the hearing.
Thanks. Thank you, Finn. And you are a statewide service, so these services are available to regional people in the same way as people who live in the metropolitan area of Sydney. Is that right?
So we do provide a statewide service for particular forms of work that we do. We do work alongside the Department of Forensic Medicine as well. So based on the catchment area, it does vary as to which team or which agency is responsible for having particular discussions with families. But certainly for organ retention calls, senior next of kin and burial disputes, and objection matters and matters where an organ has been requested to be retained, we would be overseeing a statewide service offer. Inquest support, unfortunately, we're not able to travel to regional courts ordinarily. It's something that we typically wouldn't always be able to do based on capacity and staffing. However, we can provide virtual support to families. We often receive referrals from local courts indicating that a family may be needing some sort of debrief or some sort of informational session. I should say as well that the viewing sessions, the supportive viewing sessions that we undertake, it's not necessarily only in matters where a case has gone to inquest. It's very often the case that we'll receive referrals from police advocates, coroners as well, requesting that we undertake a supportive viewing with families if the coroner has approved that particular materials be released to the family or be viewed by the family. So that is also a statewide service that we can provide, in which families may nominate to travel to the Sydney court where we're located, or we can facilitate those supportive viewings via Zoom.
Thank you. So you've explained a bit about how there's an investigation that occurs and the coroner will make directions during that process. What are in broad terms, the steps that have to happen after a death is reported to a coroner?
So once a death is reported to a coroner, so it ordinarily would be done through the police completing what we call a P79A report, and that would outline the identifying information about the person who has died, so name, age, address, contact details as well, inclusive of when that identification hasn't been undertaken by that stage. It will provide available information about the senior next of kin and a summary of the incident as well. So it's quite a thorough report that police are required to provide to the coroner, which would be received by the CCMU. And following this, this does trigger the initial stages of the investigation. What that would typically involve is forensic medicine seeking to collect relevant information about the person's medical history, police obtaining information about the circumstances of the death, and trying to complete identification as well if that hasn't occurred at the point that the death is reported. But further to that, a triaging discussion will occur in which, if a senior next of kin has been identified, either my team, some of the social work staff in a different department at the moment will be calling the senior next of kin to discuss the role of the coroner, the next steps that occur once a death is reported, and to obtain the family's views about particular levels of examination that may or may not take place. So police are required to try to ascertain an objection status of the family when the death occurs. But when a person is in shock or when they may not wholly understand the role of the coronial process, it's important that we have a discussion facilitated with the family. It's not our team that's undertaking these calls, but it is part of that intake process to reach out to the senior next of kin and establish their views on the coronial process and next steps. Typically, in that process of triage, as we collect clear information about the circumstances of the death, that would be for metropolitan matters. At times that would involve undertaking a CT scan, obtaining information from hospitals or general practitioners about a person's medical history. The forensic pathologist would review this information and issue a recommended coronial direction for the coroner to review, in which they would make a recommendation about the level of examination that may be required to ascertain the cause and manner of death, make a basis recommendation as to whether this initial review has led them to determine a cause and manner of death on the balance of probabilities, and the coroner will consider this recommendation and either indicate their acceptance, or they may decline that recommendation and issue an alternative pathway. So it can vary case to case, but for example, a general example may be that the forensic pathologist reviews the information made available through a CT scan or a review of medical records, and may see that a post-mortem examination is necessary. The coroner may take into account the views of the family if there's an objection and consider whether that examination does need to go ahead in light of the family's views. The coroner does strive to take a family's concerns into account. So at times an alternative direction for a coroner certificate may be issued. It really does depend on the circumstances of the case. It's very hard to say what it looks like for each one, but typically the coroner does need to ensure that the family's concerns are being taken into account. But further to that, the coroner is guided by the Coroner's Act of 2009, which states that the least invasive method of examination needs to be undertaken to ascertain the cause and manner of death. So if the coroner is of the view that the cause of death has been identified on the balance of probabilities, they're typically not legislatively permitted to go further unless there is that legitimate need. Now, what's important to note that if it is seen to be a natural death, a death that's resulted from the progression of disease or abnormal pathology, it's common that the coronial certificate pathway is taken. Or if it's an unnatural death, however, it is more likely, and when I say unnatural death, something that is not the result of natural progression of disease or abnormal pathology, it's not unusual that a post-mortem would be recommended by the coroner. And a post-mortem examination can vary in the level of invasiveness dependent on the circumstances of the case.
From what you've said, the process can be reasonably lengthy. And we do have an audience question about that, and I guess the stress that families experience because of the length of time involved. But it sounds like there's quite a lot of investigation that happens that makes it a lengthy process. Would that be right?
It really can vary based on the circumstances of the case. Of course, it's very, very hard for us to say what the specific time frame would be. Typically, we want to be undertaking as timely a process as possible, and usually it is raised to us if it is a priority matter in which there may be particular personal or cultural concerns raised by the family in wanting the body to be released in a timely manner. It's very hard for me to say what the exact time frame can look like, because there are so many different pathways so many different outcomes that could come from a coronial investigation. At times, a doctor's medical certificate may be obtained by the clinical nurse consultant. And if this is accepted by the coroner no longer has jurisdiction over the matter, so a body release can occur quite quickly. A coroner's certificate outcome, typically that shouldn't, from what I've seen, that could approximately, based on the circumstances, take 5 working days, well, roughly 5 to 10 working days I've seen it be completed in, but then again, I've seen it be completed in a lot shorter time. So it's very, very hard for me to say what the exact time frame would look like. But typically where it's a straightforward coronial matter in which the family is accepting of the coroner's findings, we wouldn't see that to be the most lengthy process in terms of a coronial investigation. Where there's an examination or request for specialist testing, that can take longer because it's more invasive. And then when the examination is complete, of course, we can facilitate the release of the body, but the investigation itself and the findings, particularly where an examination has taken place or in the cases where the matter progresses to inquest, that can take several months to a year or so for families to potentially have more clarity, answers, or the final investigation findings be released. So with timeframes, it's very, very hard for me to say an exact clear-cut time frame. We always strive to ensure that we are providing as much clarity within reason to families as we can at the earliest opportunity, but it just depends on the circumstances of the case and what level of investigation is required.
So in some circumstances, an inquest is mandatory. Are there particular, would you just mind outlining when an inquest is mandatory? Because you've commented that over 90% of matters don't proceed to inquest, so they're rarer than the other processes that happen. But in certain circumstances, an inquest must be held. Is that correct?
Correct. So it's about 97 to 98% of cases will not proceed to inquest, but there are circumstances in which an inquest is mandatory pursuant to Section 27 of the Coroner's Act. So in cases where there are suspected homicides, not suicides, cases in which a person has died in custody or as a result of a police operation, and that's pursuant to Section 23 and 27, respectively, of the Coroner's Act. When the evidence does not sufficiently disclose whether a person has died, so missing persons cases, when evidence does not sufficiently disclose the identity of a person who has died or the date, place, cause, or manner of their death. So in cases in which the investigations undertaken by police and the Department of Forensic Medicine still do not assist or still do not allow the coroner to have a clear determination about the identity, date, place, cause, and manner of death, or when the minister or state coroner directs that an inquest be conducted. So they're the circumstances in which an inquest is mandatory.
Thank you. I might turn to some audience questions now. Is there anything else either of you wanted to add before we turn to audience questions?
Yeah, I just wanted to say that I'm mindful that it's quite a complex jurisdiction, and part of our role as well is to provide transparency to families, bereaved families, about our processes, why particular decisions may or may not be made, but we also welcome inquiries from community members, particularly those providing support to families. Realistically, we're not able to, I mean, we're quite a small team, so we see it as really vital to be able to support families through providing information to community services as well. So I'm more than happy for anyone to call me or send an email to the CISP generalist email if you had any questions, inquiries, or thoughts after this webinar. We really do have that open door policy, so really open to answering any questions that anyone may have in a separate email or call following this seminar.
Thank you. I've just moved to the slide that has contact information, and just to let our audience know that I will provide that information in the email that you'll receive after the webinar as well. So
Bridget, sorry to interrupt. There was just one thing actually that I should add. I know that I talked before about the fact that the Inquest unit provides advice around inquest matters. I just wanted to confirm that that does relate to things like death certificates and postmortems that Finola talked about. In terms of burial disputes, however, we can only provide very basic advice around burial disputes, so the basic procedures attached to that. But generally speaking, legal aid will refer those matters to, the Law Society or the Bar Association for further more in-depth advice and potentially representation if there's availability to do that.
Thank you. Thanks, Danielle. So there was a question for you, Danielle. Do you represent next of kin of all people in the event of a death in custody?
So usually what happens is that there's one kind of lead SNOC, so one lead senior next of kin that then represents the family. And what will happen is that we will usually have, the one person that's our client, and we'll liaise with them alongside other family members as well. But usually there's the one person. There are circumstances where families are split or there's disputes, or because there can be a number of next of kins, it can make it a little bit difficult in those circumstances. So in those situations, generally speaking, we don't represent a number of senior next of kin because there's obviously things that relate to conflict in those circumstances, but also in terms of the grant process that legal aid goes through, typically we will only represent the one family member in regards to the public interest test that we have.
Thank you. Finola, senior next of kin, is that, or Danielle, is that determined? Is there is that set out in legislation so that it is clear who is senior next of kin, or is it something that might be negotiated or disputed?
Yeah, so Section 6 of the Coroners Act provides a definition for the senior next of kin in ascending order of priority. So the coroner has no jurisdiction to make a determination regarding competing claims for senior next of kin for people who are on the same level of the hierarchy, such as multiple parents or multiple children of siblings. So essentially the hierarchy would be a spouse or de facto partner. In the absence of a spouse or de facto partner, it would be adult children. In the absence of adult children, parents. In the absence of a parent, siblings. So it does go through quite a clear legislative hierarchy in a sense. And it can be difficult for families to comprehend sometimes, as there could be someone who was very, very close to the person that was deceased, a sibling or a child, but if there's an estranged partner or a family member higher up on the hierarchy who's estranged, the Act doesn't, I guess, speak to the closeness of the relationship in particular. So it is guided by Section 6 of the Act, and of course families may wish to dispute senior next of kin appointment in the Supreme Court, which can happen in some cases, but ultimately we are guided by the legislation.
Thank you. We've got some questions about whether information about Inquests is available in community languages. So I've got up on screen a link to the legal aid website where there's information when you have experienced a death, but also to an information brochure from the coroner's court. Finola, do you know if there's information available in a number of community languages?
My understanding is that our court website should accommodate, as a government website, should accommodate 2 different languages, and we do have brochures. My understanding is with different community languages, providing information and guidance about the coronial process. I think court registrar would be the best body or team to speak to about those resources. I'm more than happy to send that update or information across, Bridget, after the seminar today for dissemination.
That'd be great.
Court registrar would be the best team, but my understanding is that we do ensure that there is that level of inclusivity. We do work with interpreters quite often as well. So if families do contact the court and require verbal assistance, we do have access to interpreter services as well.
Oh, great, because that was another question about whether you provide counselling and support to families from culturally and linguistically diverse backgrounds. So obviously you're doing that if you're using interpreters.
Certainly, if we have a senior next of kin who's located overseas, which is not uncommon, we will strive to contact that senior next of kin with the assistance of the consulate or an interpreter service. So we certainly would seek to ensure that anyone, irrespective of their location or language, is provided with an equitable service.
Okay, there's another question about statistics on the different types of cases in which need for a coroner's investigation has been identified. For example, whether an unexpected death in hospital, death in custody, or serious accident in public places, whether there would be statistics. I imagine as a government body that the coroner's court would keep statistics, but whether they're publicly available or not, I don't know that either of you would be able to answer that. But we might be able to, sorry, Danielle.
I was just going to say, I can answer one part of that. I think in terms of getting real-time statistics on death, it is quite difficult. However, the Attorney General recently just launched a real-time dashboard in relation to deaths in custody. I'll post the link in the chat in response to that answer. But you can go onto this platform and you can see the numbers of deaths that have occurred in custody for both First Nations and non-First Nations people. It breaks it down into whether it's prison or police, male, female, age groups as well. So I'll just add that in.
Thanks very much, Danielle. And then I'll also include that link in the email that goes out to people who registered for the webinar.
Yeah. I think I can only respond to the answer, so hopefully that goes through to everyone.
Finola, there's just a clarifying follow-up question about whether counselling services are only provided to called senior next of kin.
Yeah, that's an excellent question. And I guess it provides that opportunity for me to discuss I guess where the counselling ends and begins. I guess we don't promote ourselves as a counselling service per se. We are an information sharing service, but we have the clinical skill sets and experience to respond to clients' experiences of grief and distress. So we, of course, can refer families to longer term support services if we do identify there to be long-term support needs. So I guess that's providing clarity about one part of the question, though. We would be communicating about coronial orders and coronial directions with the senior next of kin, as in accordance with the Act. That is the person who's required to provide response to the coroner in when particular directions are made. So in terms of disclosing information about coronial directions, examination processes, that would be the senior next of kin. But of course, if an inquiry is made by the court, made to the court by another family member or another interested party seeking information, we can talk to them about the process of making requests for information. So to potentially be listed as a next of kin on court records, they would be making key decisions about the coronial matter, but it wouldn't preclude them from accessing information. At times, an interested party may wish to undertake a supportive viewing, so supporting that family to make that request to the coroner. Of course, we typically would have to notify the senior next of kin that this request has been made, but in answer to your question, we wouldn't decline a person access to information within reason. We are not able to release all of the information that we have to any person that inquires about, but we would talk to families about what the process looks like for making requests for information. So we really do adopt that no wrong door policy, and even if we're not the correct team to speak to, we can refer the interested party to other stakeholders who may be best placed to answer their inquiry, such as the officer in charge, Department of Forensic Medicine.
And in terms of families that may need more ongoing, longer term support following the process that they've been involved in, I imagine you make referrals to other services that might be able to support families in the longer term.
Yes, we quite frequently refer bereaved parents where there's been sudden infant loss to Red Nose, which is a nationwide organisation in place to parents who've experienced perinatal loss. So we quite often make referrals to Red Nose. We will support a family member to link in with their general practitioner as well to obtain a mental health care plan. And where there are children that a bereaved parent is supporting or a bereaved family is supporting, really encouraging engagement with services such as Headspace or the school counsellor at the children's school, who are required to take a proactive role when a sudden loss has been experienced. We also make referrals in New South Wales to the Grief Line Integrated Grieving Program, which is actually a relatively new service that can provide virtual counselling for free to families for, I believe, 5 to 10 sessions. And they actually streamline the counselling services in accordance with the nature of the loss. So if there was a sudden loss and a person requires acute mental health first aid, there's a counselling stream associated with that form of counselling. And there's also services for prolonged or complex bereavement, where it may be years after the loss that someone is requiring support. We can make that referral. So that's a service that I think is really important to share information about, particularly in considering presently cost of living pressures. Accessing psychological services is not always feasible or affordable for families. So I've been making referrals to that service recently as well. And I can send some information about that to you after the seminar to disseminate if anyone has a client that may benefit from that service.
Thanks. There is one last question. I don't know that either of you would be able to comment on it necessarily, but it's about developments in genetic science and the impact that they may have had for change in the coroner's court jurisdiction. I don't know if either of you have observed the impact of developments in genetic science in that jurisdiction or not.
Look, I can't speak to it specifically, but what I can say is, because obviously I'm not from the coroner's court and I don't know what their position is, but what I can say is that what I think this case highlights is that the law remains somewhat stagnant in some areas, and science continues to expand and grow, and we're learning new things from that at all times. And the one really good thing about the coroner's court is that the rules of evidence don't apply. So there's evidence that can be brought before the coroner, specifically in relation to genetic science, that they can take into account when they're looking at a matter, which I think is quite insightful and important.
Yes, whilst I'm not an employee of the Department of Forensic Medicine, so I'm a little bit reluctant to comment fully as it's not within my skill set and expertise. I would say that there is a commitment to service excellence in line with contemporary research and evidence, which can include all developments in forensic science. So once again, whilst I'm reluctant to speak fully to that, all developments in fields relevant to coronial investigations would be incorporated in the analyses.
Thank you. I note the time, and I'll close the webinar off now, but I wanted to thank both of you for the wonderful information that you've shared in the webinar today, and to thank our audience for the questions that you've asked to draw out some additional information. And just to let people know that this webinar has been recorded, and it will be in the next week or so uploaded onto Legal Aid's YouTube channel, so you'll be able to come back and view the webinar again if you'd like. And of course, we will send out an email with the resources and links that we've all spoken to today. So thank you, everybody. I will close off the webinar now. Thanks, Finola, and thank you, Danielle. Bye, everybody.